Do you have any concern about the complexity of the rule that you are advocating? If it were limited strictly to a situation like Rahafe, fine, everybody could understand that. But are you concerned that every federal prisoner who wants to bring a successive motion is going to claim that this falls within the traditional scope of habeas, and this would be an escape clause that will be invoked again and again and again, and all the district judges are going to have to analyze the traditional scope of habeas and see whether the claim actually falls within that?
No, Your Honor, we're not worried about that for two reasons. Number one is, as I've described the world of habeas, the conditions of confinement claims are already dealt with in 2241, and then on merits claims, we have the constitutional and factual claims that are like state habeas. Those are already addressed. We've dealt with those, and then we're just left with these kinds of statutory claims. The only kinds of statutory claims that you could possibly ever bring under successive and abuse of the writ doctrine are going to be claims based on intervening decision of this court. And that's going to be a set of claims, but that gets to my second reason, which is under both successive habeas petition doctrine under Coleman or abuse of the writ doctrine under McCleskey, for example, you will see that that is going to require a showing of actual innocence that's going to be very hard to make and can get knocked out pretty easily at the threshold.
Well, let's say I'm a district judge and I haven't dealt with this problem before. Give me your best summary of the rule that I should apply when I get an effort to file a second or successive habeas petition.
Well, Your Honor, honestly, I can't tell you that it's impossible that there's some implication we haven't foreseen, but we really think this is, as far as merits claims go, essentially probably a category of one. So you look to see whether it is the type of claim that we're dealing with here, a purely statutory claim that asserts that somebody is in prison for something that Congress never made a crime. If so, can that person make the threshold necessary showing of actual factual innocence under Boosley, which can take into account not just the evidence that was presented at trial, but all the evidence that could have been presented. And we've stated in our brief, and I'm happy to restate here, all the reasons why petitioner can't even get